having come in a bit late. The reason being, our class was supposed to be conducted yesterday. However, we were slightly late. So we shall be a bit swift so that we can have at least an idea of what we are going to handle in workshop 1. So for purposes of emphasis, this is your second class of civil procedure, and it is known as special proceedings. The reason why they are referred to as special proceedings because the kind of procedure they deal with is basically under a different category of law, unlike other proceedings we've been having. And this law encounters all aspects, that is to say, how to file pleadings, how to serve hearing. The timelines are a bit different. So that's why they are called specialized proceedings. Under these specialized proceedings, we shall look at electoral petitions, we look at judicial review, and then we look at enforcement of human rights. So basically, let us start with electoral petitions. Are we having the laws with us? Yes? Is there anyone with the act? Do we have someone with the constitution?
Yes, I have the constitution.
Okay. First, take us to Article 60. Okay, before we go to that, when you are dealing with electoral petitions, you should be able to realize that we have a couple of categories of electoral petitions that you need to appreciate. Electoral petitions are brought in circumstances where one is challenging the outcomes of a given category of elections. First things first, what are the different categories of elections? In the first place, we have what we call presidential elections. And then if anyone wishes to challenge presidential elections, we proceed under the Presidential Elections Act. And the court that has jurisdictions to handle them is the Supreme Court of Uganda. Then we have what we call parliamentary elections. In the instant case, when you look at your workshop, it's basically on parliamentary elections. But that does not warrant us to basically move alongside the same line. Okay? Only. What it requires that we should put into consideration other petitions. Okay. Then lastly, we have what we call the local government elections. These are governed by the Local Governments Act. So you should be able to appreciate the fact that they do also exist. Because when you get a workshop or an IA, the first thing you need to appreciate is one, what type of elections are we dealing with? That's the first thing to appreciate. Because failure to appreciate it, you'll end up proceeding with wrong advice. Okay? Are we together? So then after analyzing that, then we have to zero down to the different laws that give a citizen a right to vote. Okay? So, Councillor Judith, let's start with the Constitution. Or we just hint on these laws, we shall read them at a later stage. When you look at Article 59, it provides for a right to vote. It says that every citizen of Uganda of 18 years of age or above has a right to vote. Okay? It is your right to vote. Then, after understanding that it is your right to vote, then you go to Article 60, which establishes the Electoral Commission. Article 60, subsection 1. It establishes the Electoral Commission. Okay. Then, after that, you go to Article 61, which gives us the functions of the Electoral Commission. It says that the Electoral Commission shall have the following functions: to ensure regular, free, and fair elections are held, to organize, conduct, and supervise elections and referenda in accordance with the Constitution, demarcate constituencies, ascertain, declare, seal, and results, compile, revise, and update the voters' register, to determine complaints arising out of elections during polling, etc. So when you are reading Article 61, put it into consideration that we are dealing with functions of the Electoral Commission. Remember, it being the ultimate body to handle such matters in the country, it has to ensure total compliance with the law because it is the custodian of the electoral laws. So when you are reading the facts, make sure you've appreciated functions of the Electoral Commission. So to further your understanding on the same, you should visit what we call the Electoral Commissions Act as well. The Electoral Commissions Act. Anyone with the act? Okay, so we go to the Electoral Commission Act. When you further read in details the Electoral Commissions Act, it is very emphatic on the different duties of the Electoral Commission and how it is supposed to be independent. Okay, so what you should put emphasis on Section 12 of the Electoral Commissions Act and Section 13. Section 12 gives you other functions of the commission and how to regulate ballot papers. The reason why we are so emphatic on looking at what we call functions of the Electoral Commission, in your facts, you'll see circumstances where the Electoral Commission failed to execute its functions and duties, which are mandatory under the law. That's why you've been seeing, I know you've been having some workshops where you see people raised issues, whether there is non-compliance with the electoral laws. The non-compliance comes from both the sides of the candidate and the Electoral Commission. But for you to purposely appreciate the functions of the Electoral Commission, it will be of good hope for you to understand the non-compliance. Okay? When you look at Section 12, some of the functions it highlights is to design, print, and control use of ballot papers, provide, distribute, and collect ballot boxes, establish and operate polling stations to ensure measures the entire electoral process is conducted under conditions of freedom and fairness, etc. A good example are in last year's general elections, you realize that we had, when we are dealing with local government elections, LOC 5, LOC 3, because it is the duty of the Electoral Commission to ensure that they print. You saw ballot papers of LOC 5, LOC 3, and some councillors. Where there was NRM, it was a symbol of an umbrella. Where it was people power, it was a symbol of a bus. So that was a non-compliance. They didn't effectively, okay, but it was a printing error that was corrected at a later stage. So when you look at such, it is a duty they should execute with due diligence. So when you are reading facts, put such things at the forefront. So after us analyzing the duties, how the Electoral Commission is conducted, okay, and maybe for purposes of, when you look at Section 13, independence of the commission, a commission should not be influenced by any person in making a decision, by any person. So where you see that maybe a returning officer made a decision in front of so and so, that is a question of independence. Did it execute its obligations relying on its independence or with influence of other persons? Okay. So then after realizing that we are dealing with established the Electoral Commission and its mandate, So we realize that we have a couple of elections, okay, that we deal with. Under this, we said you have presidential elections, then we have parliamentary elections, and then we have what we call local government elections, okay? So let us zero down to what we call parliamentary elections, because our workshop is entirely dealing with parliamentary elections, okay? So are we together? Members, are we still on? So when you look at Article 77, it establishes the Parliament of Uganda. Then Article 77, Clause 2, says that the Parliament shall be composed. That's subsection Article 3. It is Article 77, Clause 3. Okay. It talks about the tenure. Okay. Basically, read Article 77 and then 78, which says that the Parliament shall consist of members directly elected to represent their constituencies. That is Article 78, Clause 1, Paragraph 8. So we are interested in that. Parliament shall consist of members directly elected to represent constituencies. Remember up, we saw that the Parliament, we've seen that it's composed of members directly elected. As we were starting, we looked at the rights of citizens, where they said that every citizen has a right to vote. So that means you can vote for a member of parliament, president, or local government representatives. But as of now, we are dealing with representation of members of parliament. So now you ask yourself, what are the qualifications of someone to stand as a member of parliament? So now, when we are dealing with parliamentary elections, we always raise 3 to 4 fundamental issues. Reason, the process of elections is divided into 3 stages. One, we have the stage of nomination. We have the stage of campaigning. We have the stage of voting. We have the stage of declaration and gazetting. And then lastly, we have the stage of challenging the outcomes. Those are the 5 stages. So when you are raising your issues, they should flow exactly. Yes?
Council, if you can repeat those stages and
we've said that when we are dealing with parliamentary elections, they are divided into different categories. For you to be able to appreciate them, visit these 5. One, we've said we have what we call nomination. It's the first step, nomination. So your first issue would be whether Rashid was validly nominated. That should be your very first issue, whether Rashid was validly nominated. So when we are looking at whether he was validly nominated, we look at what we call qualifications and disqualifications of a member of parliament. That's the issue shall solve first. Then the second stage after this person has been nominated is what we call the campaigning stage. During the campaigning process, there are a number of things that keep on happening. Under this, we shall have commitment of illegal practices, stroke electoral offenses. Okay, then you raise your second issue, whether there is commitment of any electoral offenses. Then the second step will be voting. During the voting, that's where we are supposed to comply with all the electoral laws. The Electoral Commission is supposed to bring all the necessary requirements within time, updating the voters register, supplying people with voters cards, etc, etc. So under that process of voting, we shall have what we call non-compliance with the electoral laws. Then you raise your third issue, say whether there is any non-compliance with the electoral laws. And we've said that under the process of voting, the non-compliance is both on the side of the candidate and on the side of the Electoral Commission. Okay. Then after the voting, we have what we call counting and declaration. Also under counting and declaration, it also falls under our third issue, the non-compliance with the electoral laws, because under declaration and the counting of votes, we know the duty of the returning officer. The returning officer will fail to sign declaration forms, which is not the way to go. So it is a non-compliance. Declaration forms will be there, but one of the agents of a particular candidate may not be represented. Okay, which is another problem. Okay. Then after that, ask yourself, we've declared, then what are the different ways of challenging? What remedies are available? So that's the way we are going to be flowing. Very simple and precise. So let's start with our issue one. Okay. Let's start with our issue one. Our issue one has been, someone to echo the same.
It's whether the person, let me say X, was rightly nominated.
Okay. Okay. It is whether this person was validly nominated. So when you are dealing with the nomination, look for what we call qualifications of a member of parliament. We first go to Article 80. Article 80 says qualification and disqualifications of members of parliament. A, you should be a citizen of Uganda in the first place. Okay? I will not comment on that. Then you should be a registered voter. Rumor has it, I am not certain that one of the presidential candidates wasn't a registered voter, and this person did not vote. Then C is so mandatory. It has caused a lot of problems. We have has completed a minimum formal education of advanced level standard or its equivalent which shall be established in the manner and at the time prescribed by Parliament. That one has completed a minimum formal education of advanced level. Okay, we first mark that. We are going to come back. Then Article 80, Clause 2. Okay, it also gives you other. We are interested in A, you should be of sound mind. Then B, you should not be a culture leader. Then you should not be holding in any office which may involve a responsibility connected to the conduct of an election. For example, we have RDCs, deputy RDCs, etc., etc. People under that category, they have to first resign from office, as we shall see. Okay? Are we together? On that very point, you have to make reference to Article 80, Clause 3, which is very particular that a local government council or a public officer shall resign from office before assuming office of a member of parliament. So if you want to stand for any post, any vacancy of a member of parliament, and you are occupying any office, you should first resign from that office. Okay? But that article does not prescribe when, but we shall tell at a later stage. Okay? So after analyzing all that, we have to put emphasis on what amounts to a minimum educational requirement. So after looking at the Constitution, now ask yourself, which law basically deals with parliamentary elections? Then we shall go to what we call the Parliamentary Elections Act. Are we still at the same page? Members, are we still on the same page?
Yes, yes.
Okay. So now, when you are dealing with this act, remember we are still basically looking at the requirements. We are dealing with our first issue of being validly nominated. Okay. Remember, we want to establish whether this person was validly nominated. I told you our emphasis is going to be on the minimum requirement of education. Okay. Okay. So when you go to section 4, section 4, are we all there? Subsection 5, it says, for purposes of paragraph C of subsection 1, any of the following persons wishing to stand for election as a member of parliament shall establish his or her qualification with the commission as per holding a minimum qualification of advanced level or its equivalent at least 2 months before the nomination day. Underline that time. At least 2 months. So that means if you want to prove your minimum education level, okay, you are supposed to do that at least 2 months before. So they'll show you when someone did it 1 month to the nomination day. Does the law, because if it says at least, it means the minimum should be two months. So you shouldn't go below that. So they'll give you facts where Rashid represented his academic credentials 1 month to the nomination day. Okay? And mark that. Okay? We shall establish something else as well. Okay? So then A, they say that persons, whether their qualifications are obtained from Uganda or outside Uganda, okay, from Uganda or outside Uganda, who are claiming to have their qualifications accepted as an equivalent to advanced level, okay. Now, under that, we have persons who have studied outside Uganda, that is to say Kenya, Rwanda, Tanzania, UK, etc., whatever the case may be. Then we have in Uganda, we have people with diplomas in music, dance, and drama. Okay? So when you are looking at that, put it into consideration. It is your duty, not the duty of the electoral commission. Okay? Then ask yourself, if you have a certificate outside Uganda or a diploma, how do we do that? Okay? This is done by what we call equating of results. Equating of results. So ask yourself, who has the duty to equate results? Then you go to section, okay, go to subsection 6 of that very section we've been reading. A person required to establish his or her qualification under subsection 5 shall do so by production of a certificate issued to him or her by the National Council for Higher Education in consultation with Uganda National Examination Board. Okay, so that means you don't produce your certificate of an award of a diploma. You take your diploma where? To National Council. Then the National Council will consult UNEB because it is the chief examination board in Uganda. So that means it has your results. Okay, then they will start doing the equation. They see whether you qualify or you don't qualify. So for you to understand what amounts to equating, that's why you have to go and read the National Council for Higher Education's Act and then the Uganda National Examination Board Act, UNEB. That's why they are attached on your workshop. Okay? Are we together, colleagues? Members, are we together?
Yes, Council.
Yes, we are.
So now, we've seen a number of cases that have been talking about that. Even in the current era, even in 2021, we had a couple of parliamentary elections where such challenges were faced. So the question is, what is the most appropriate case in reading that? Okay. On your reading list, though I'm not with it here, I'm very sure you have two prominent cases. Look at the case of Betty Nambo Zebachireke on your reading list. It is very emphatic on academic qualifications. Then the case of this Nasana guy, Zitu Wakaima. Okay. Those two cases are so emphatic on the academic qualification.
The numbers, Council, the numbers of the case.
I'm not with the reading list with me. I'm just using them offhand.
Better numbers is
Council for
number
Wakaima.
33.
For
For Wakaima
Wakaima
is
is number 17.
yes, you look
Number
at case
17
number
going
17.
number 33.
Number 33 and number 17 on your reading list. Those are the two cases you should read on academic documents. Even reference can be made on the case of Katol Wama, the late Katol Wama. May his soul rest in peace. But I don't think it is on your reading list because it's so recent. Okay. So we go on. So now, after looking at all that, then the second thing you ask yourself, we are still dealing with nomination, validity of being nominated. Then ask yourself, when we are dealing with parliamentary elections, we have two types of parliamentary elections. We have what we call general elections and then by-elections. So when you are reading, ask yourself, what type of parliamentary elections am I dealing with? Am I dealing with general or by? Reason, some of the qualifications we are talking about, they have the time frame, but the time frame in general elections and then by elections is different. So when you are reading, ask yourself, am I dealing with general elections or by elections? Let's go to section 2. Someone read for us section 2 of the Parliamentary Elections Act. When you look at section 2, it is very clear, okay? Section 2 says a general election of a member of parliament shall be held in accordance with Article 61, which we read, okay? Then 3, it's what we call by-elections. Section 3, look at the circumstances under which a by-election may be conducted. We have one where a member of parliament dies, then B, where the seat becomes vacant, under what circumstances? Where an MP has been declared bankrupt, has become of unsound mind, okay? And then someone has been disqualified by court that this person was not validly nominated, okay? Once you are disqualified, the seat will become vacant, okay? So when we are dealing with by-elections, when should they be conducted? We've seen the circumstances, but we have the time frame. It says the clerk of parliament shall notify the commission within 10 days. So where the seat becomes vacant, the clerk of parliament within 10 days notifies the electoral commission. Then upon receiving the notification, the electoral commission shall conduct a by-election within 60 days. Within 60 days. But where the term of an MP is remaining 6 months to expire, so that we reach a general election, a by-election should not be conducted. Okay? We are going to understand why we are reading this. Okay? So upon you appreciating whether you are dealing with a general election or a by-election, then ask yourself, okay? Ask yourself. Remember we said that you should leave office. You should leave office. When you go to section 4, subsection 4, are we there? Of the Parliamentary Elections Act, okay? It says in case of a general election, okay, a public officer should resign, underline the word resign, his or her office at least 90 days before the nomination day. So you'll be given facts where a public officer did not resign from office in the first place, okay? When this person just went for leave, If not, this person will have resigned, but not within. Because when they say at least, that means the minimum is 90 days. They'll give when this person resigned 1 month to the nomination day. That means it is below the minimum time set by the act. And if this person resigned, that means within, let's say 30 days, 20 days, and then the electoral commission went ahead and nominated him. That means he was not validly nominated. Okay. Then also in circumstances where it is, then paragraph B, in case of a by-election, a public officer should resign from his or her office at least 14 days. So you see the difference. So when you are dealing, first understand, is it a general election or a by-election? That's the starting point. Okay. So once you realize all that, when you are reading your facts, you'll be able to understand that this person was not validly nominated. And you resolve that issue in affirmative. Are we all together on issue 1?
Yes, we are.
Okay, so now we presume that this person has now been nominated. Okay, this person has been nominated. Okay, but before nomination is complete, there are certain things we should put into consideration. Okay, we should put into consideration. What are such things? Okay. When you look at, so the process of nomination is under section 9. Okay. Now, when you look at section 10, sponsorship of candidates by political organizations or political parties, that implies that every candidate who is under a political party should bear a symbol of that political party. That's what we call sponsorship. However, under such circumstances, we have what we call allocation of symbols. Okay. Allocation of symbols under section 17. Where you are a candidate who is independent, you get your symbol, you use your symbol as you. Okay. So what does that mean? After the nomination process has been concluded, when we are going in for campaigns, your symbol should be at the foreplay. Okay, that's how we will be identified. So they'll give you facts where we have 2 candidates who are using the same color and the same symbol. One was seriously disciplined, where in the primaries, because he or she believes is stronger than that person, the party decided this person will become independent. And once he comes as an independent, the end result will be using the symbol of the political party. Okay, so we should put all that into consideration. Okay. Are we together? So now, after nomination is complete, our next step is what we call campaigning. So what happens in campaigning? Here we have what we said during the campaigning process, we have non-compliance with electoral laws, and then commitment of electoral offenses. So let's start with non-compliance. Are we at the same page, colleagues?
Yes, Council.
Okay, so now let's go to section 20, which talks about campaigning. Okay, so when you look at section 20, what are we looking at? Okay, we are looking at time when campaigning start and end. Section 20 subsection 3 says that a campaigning meetings of the candidate, a candidate is at liberty to use any language. Then subsection 4 says that the campaigning meetings shall not commence until the expiration of the nomination days. It is expiration of nomination days, not expiration of the nomination of a candidate. So they will give you facts where from the day of nomination, one of the prominent candidates, aka, started campaigning that very day. When nominations have not yet been concluded, so it becomes a non-compliance. The candidate has not complied with the electoral laws. Okay. Then another one, the campaigning meetings shall not be held within 24 hours before the polling day. What does that mean? That 2 days to the polling day, campaigns should end. You'll find a candidate who's campaigning even on the day of elections or even in the night. You do these things. I want to highlight, Jeff, you did these things in your campaigns. Okay. Then you go to section 22. Okay. Sets out rights of candidates. Okay. One, regardless of the fact that when you look at 22, a candidate has a right to campaign using all, okay, the laws. So your campaigns should be within the law, okay? And they are giving you the different things you should use, okay? So when you look at a subsection 6, it gives you what we call prohibited actions, making statements which are false. You get it, okay? Making malicious statements, making statements containing sectarian words, okay? Making abusive, insulting, derogatory statements, making exaggerations, or using derisive or derisive words against the candidate, using songs, poems, and images of any so those are activities that are prohibited. Once you do them, it is a non-compliance and it becomes an offense under subsection 9. Any person who contravenes subsection 3, 5, and 4 commits an offense. So it becomes an offense. Okay. Same applies to section 23, non-sectarian campaigns. Okay. All that happens in campaigning. You've seen these things happening. Okay. Then interfering with electioning activities. Okay. You stop some people from. Then when you go to 25, during campaigns, we are looking at campaigns. 25, okay, use of government resources. They are going to give you facts where you have an RDC who kept on using the local government vans. It says, except as authorized under this act, no candidate shall use government or public resources for purposes of campaigning. I will not comment on that. But you know better. We've seen persons using government resources for campaigning. Okay? Are we together? So for you, when you are given facts, look out for those. Those are what we call non-compliances during the campaigning process. Okay? Then, during the campaigning, we have what we call electoral offenses. Okay? What offenses are committed during the campaigning process? Okay? I know we have politicians here, but most of you are victims of the sections we are going to read. That I'm very sure. Okay? But Allah will guide you according. Okay? So, when you look at section 73, okay? You'll be reading from section 68, okay? The first electoral offense that is committed during campaigns, it's what we call bribery. Bribery. Yeah. Should we read that section? Let me see which politician here will help us. Council Juma. How do you understand the offense of bribery and when campaigns are being conducted? Yes, Council Juma, you can unmute. Just for academic purposes. Yes, Council Juma, we together. Are you on? Council Nasa. Okay, so when we are dealing with bribery, when you read section 68, first understand who can commit bribery and under what circumstances and who can be charged of that offense. Section 68, a person who either before or during election. So before, it's during campaigns. Okay, so that means this offense can be committed during campaigning or even after campaigning on the polling day. Okay, with intent either to directly or indirectly influence another person to vote or to refrain from voting any candidate, gives that person or causes to be given or provided any money, gift, or other consideration of that other person, okay, commits an offense of bribery and is liable on conviction to a fine not exceeding 20 currency points or imprisonment not exceeding 3 years. So the first person, a person who gives, okay? Then subsection 2, a person who also receives the bribe commits an offense. Okay? Mark that. Okay? Mark that. So this offense is committed either by the candidate or through the candidate's agents. The things we've been seeing practically, okay? So then ask yourself, under what circumstances, okay? Are we together? Will not this offense stand? You go to subsection 3, okay? Where the candidate or the candidate's agent was providing refreshment or food. Refreshment or food, okay? You've found people, you buy for them soda, you buy for them water, okay? Then that amount does not amount to bribery. But the question of food, cases have been contradicting on this. Some cases are saying that food should be already prepared food, not to amount to a bribe. That is the question of fact, okay? That it should be prepared food, not to amount to a bribe. I don't know. You read the case of Betty Namboze Bachireke as well. It is very emphatic on that, okay? Then you also read the case of Dr. Kanokiza Besije versus YMK Museveni, electoral petition number 1 of 2006. Okay? Actually, in all the electoral petitions of Dr. Kanokiza Besije versus YMK Museveni, that offense of bribery has been dealt with. Also, you can refer to the case of Amama Mbabas and another versus YMK Museveni and the Electoral Commission. Okay? It is also emphatic on that. Okay? So mark the lines. Okay? I know people have been victims of that. But wait, the day we shall sue people who receive the bribe. Oh, aha. Some of you may not survive the reign of terror. Okay? Then another electoral offense is procuring prohibited persons to vote. Okay? I think the case on this is not on the reading list. We have the case of Paul Kawanga Semugerere versus the Electoral Commission and another. Remember those voting? The so-called people from Buganga is, okay? So when you read that case, Paul Kawanga Semugerere used to ferry people from Buyaga, they come and vote from Buganga is. Then after voting from Buganga is, they go back to Buyaga and they vote. Then after they come to Kayunga, that is procuring of persons prohibited to vote. Under this, you look at persons who vote twice. It's also an offense. Under that, you know that this person has already voted. Okay? If not, they'll give you facts where I am a resident of Nakaseke Ngoma, but I'm voting, I'm being procured to vote from Kawempe. Okay? So that is an illegal practice. Okay. Then we have obstruction of voters under section 71. Okay. Then under section 70, we have what we call publication of false statements as to illness, death, or withdrawal of a candidate. This matter was not concluded, but it was inclusive in the case of Sulaiman Chidandala versus Muhammad Segirinya and another. You remember where some people even made posters of Sulaiman Chidandala that is coming up as Member of Parliament East Africa, that he has withdrawn from the race. Okay. So that was a false statement, but that all those were inclusive in their petition, but the petition got any problems. Okay. And it was not concluded, it was aborted under the law. Okay. Are we still together? Members, are we still at the same pace?
Yes, Rashid.
Okay, let's proceed. Okay, let's proceed. Okay, so when you look at other electoral offenses, but the offenses now I think will be a bit easy for us to identify. Okay, or we need to be so emphatic on others. Yes.
Yes, Council.
I think the rest will be easier to identify.
Yes,
So,
Council, we can go to another issue.
okay, so now, then we said we've been looking at camp, then we go to voting. Voting. We've highlighted some of the offenses that can be committed during voting. Okay. Then we have non-compliances during voting. Okay. This happened during voting. Non-compliance. Okay. Non-compliance. One of the non-compliance is campaigning during or at the polling day, which we saw. Okay. Then when you look at okay. So when you look at section 30, okay, section 30, which talks about voting and voting procedure. Sorry, section 27. When you look at section 27, it says within 48 hours before the polling day, every returning officer shall furnish each presiding officer in the district with sufficient number of ballot papers, statement showing the number of ballot papers, any other necessary materials. They are going to give you facts where the returning officer, okay, of the district, the returning officer supplied presiding officers with voting materials that very day in the morning. That will be a non-compliance in the first place. And on which side? Electoral Commission. Electoral Commission. It has not complied. That happens in, okay? Then under section 28, we have what we call gazetting of polling stations and publication under 28. The law is very clear. The commission shall by notice in the Gazette, okay, publish a list of all polling stations in each constituency and the list of names of nominated candidates. Okay, you will see that some polling stations will not be gazetted, they will be gazetted in the morning. Okay, that will be a non-compliance. Then we go to section 29, which talks about polling stations and voting time. What time should the voting start? When you look at section 29, subsection 2, it says that every polling station, polling time shall commence at 7 o'clock in the morning and close at 4 o'clock. People who vote from Nakawa, Assalamu alaikum. People who vote within Kampala generally, Assalamu alaikum. Polling stations in Kampala, they always start at around midday or at 10 when it is too early. Why? Isn't that a non-compliance with the electoral laws? So the Electoral Commission should ensure that the voting commences at the time stipulated under the Act. So they'll give you facts where time was not complied with. Okay? Are we together? Okay? Then you go to section 31. Yes?
I have a question.
Yes, Council.
Do these things, like the offenses you're trying to say, which can be committed by the Electoral Commission, the non-compliance,
Yes,
are
those
they
ones are,
fatal?
yeah, those ones
Like, are
we
they
are
fatal? Can
highlighting.
they cause?
Yes?
Can they cause by-election?
Of course, we shall see, Council, when we go to that part of challenging. You'll see. There are grounds of cancellation of an election and you go for by-election. Okay? Yes. Okay. Then, section 31, a person not to vote more than once. Okay? Then, when you go to section 32, it talks about polling agents of candidates. Section 32 says that a candidate may be present either in person or by his or her relative or representative. So that means every candidate has a right to appoint, okay? To appoint a representative, okay? So under such circumstances, they will give you facts where a candidate and his agents we are not allowed to appear on a polling station. So that means it is a non-compliance with the electoral laws. Okay. Okay. Then when you go to section 39. Okay. Section 39, factors which may prevent a person from voting. So what does that, when the voting procedure is set out, once the voting process is under this act, if you are going to vote, you first present your ndagamuntu or the voter's card. Then you check in the register. Okay, you see where your name is. You tick and then you proceed, you go and vote. So when you look at 39, it says that the claim of a person to vote at any election shall not be rejected by reason only that one of the person names has been omitted from the voters register. Okay, so once you tick, we shall presume you have voted. Once we see that your name has been dealt with in the register. But we have circumstances where you've seen people voting for others. By the time you reach the polling station, your name is ticked that you voted. Hey, go you joke with Ugandans. Okay? By the time you reach the polling station, you already voted, your name is cleared in the register under persons who voted. So how do you deal with such circumstances? Okay? So it is a non-compliance. Okay? You see all those, then you go to section 42, prohibition of firearms and ammunitions. Okay? Then section 43, use of loudspeakers at the polling stations are also prohibited. Okay? So all those, once they happen, those are non-compliance. Okay? Those are non-compliance with on the side of the Electoral Commission. In the voting, then electoral offenses on the side of a candidate, we have, that's the one we dealt with, procurement of persons prohibited to vote. We have voting more than twice. Then we have bribery, okay? Then we have interfering with voters or obstruction of voters. All of those are offenses that are committed during the voting. Okay? To again appreciate that, you read the case of Dr. Kanokiza Besigye versus YMK 7 and another. Are we together on that ground? Before we go to another step, we are still looking at non-compliance and then electoral laws. Okay? Non-compliance and electoral offenses. Then the second last part in elections is what we call counting and announcement. Okay? Counting and announcement. That is counting of votes, announcement of the results. Under this, the things we are interested in, okay? Okay? Is what we call declaration of results. Who should declare? Okay? Then we have what we call DRA forms. Okay? How should the DRA forms be? Okay? And how should they be handled? The rule is when it comes to collection of results, okay? And the declaration of results, that is section 50 and section 51. The rule is under section 50 subsection 3 that the sealed box referred to in subsection 2 shall contain the following items. One, duly signed declaration form of results. What does that mean? That all declaration forms should be signed by the returning officer and the agent of each and every candidate so that they tally the same way. They tally the same way. So they'll give you facts where at the time of declaration, counting and collecting of votes, the returning officer failed to comply with the same. He did not sign Okay, when he did not sign, that is a non-compliance. So it invalidates the declaration forms. Okay, so are we all together up to that level? If you want to understand the issue of declaration forms, you read the case of Mutembuli Yusuf versus Nagom. It is on your reading list. It is case number what? Also, you can refer to the recent case of Fred Nyazi Sentamu versus Muhammad Nsereko and another. You refer to those two cases on that issue of declaration forms.
Also, it's case number 25.
Case number 25, it is very good, even on how to draft a petition. So be emphatic on the same. Okay, are we together? So now, after the votes have been dealt with, we have collected, so the last step will be announcements. Okay, so I want you to mark this. The last issue, because the way we've raised those issues are the issues supposed to be with council, whether you like it or not, are the issues to be with in the workshop. Don't even change. Okay, now the presumption is we've counted the votes, we've collected the results. Okay, and we are good to go. So now the question is, what remedies are available in the circumstances? What remedies are available in the circumstances? Okay, so now the remedies we have, they also base on time zones. Okay, so the first type of remedy we have is a recount. A recount. Okay, so when we are dealing with a recount, we need to first look at types of recount. Okay, so you should know under what circumstances do we go for each type of a recount. Not at all times that a recount is applicable. Mark that. Okay, not at all times a recount is applicable. So the first category of a recount is what we call mandatory recount. Is what we call mandatory recount. Mandatory recount. Section 54. So let's understand under what circumstances do we go for mandatory recount and who does it? Okay, so when you are getting a remedy, when you are reading your facts, highlight the things that send you to a particular remedy. Okay, so when you look at section 54, it says that where after the official addition, underline the word official addition. So that means mandatory recount happens after the official addition. Okay, and this is what happens after the mandatory and official addition of the votes, A, there is an equality of votes between two or more candidates obtaining the highest number of votes. Okay, so where after I adding and two candidates having the highest number of votes are equal, it is a mandatory count. Mandatory. Okay, then B, where the number of votes separating the highest number of a candidate and any other number is less than 50. So when you are reading your facts, in the very first line, look at the votes that everyone is having. Look at the highest and then the second runner. Look at their difference. If it is less than 50, the remedy you have is mandatory count. But if they are not less than 50, don't go for mandatory recount automatically. Are we together, members? Yes?
Which council we are on?
Father Council.
Okay. Then the second type of recount is under section 55, which is what we call, and please mark that, let's note this. The first recount of mandatory recount is made by the returning officer, and the request should be made in writing, either by the candidate or his agent or a voter in a constituency. And that recount should be made in the presence of a senior police officer. Okay? After all candidates are present, mark that. The right to fair hearing. Okay? Then the second type of recount is what we call recount by the chief magistrate. When do we do this? Okay? When you read section 55, subsection 1, it is done within 7 days after the declaration of a candidate. Within 7 days. So count when you are given facts. First look at the day when the results were announced. When the results were announced. Okay?
Councillor
Are we together?
Rashid, are the 7 days working days or just 1 week?
It is says within 7 days, not working days. Okay? So then this application is by notice of motion supported by an affidavit. Then this application, after your affidavit, you have to attach a receipt of proof of payment of a security of 30 currency points. Security of 30 currency points. For you to understand the issue of application for a recount by magistrate's court, you read the case of Fred Nyazi Sentamu versus Muhammad Inseleko and another. I don't remember its exact number, but it was in the Chief Magistrate Court of Mengo. Okay, but I think it is miscellaneous cause. I think miscellaneous cause. I don't remember the exact number, but you refer to it. It explains very well because that application was dismissed. Okay, so look what it says after declaration. Okay, so now okay, now If you can't exhaust that remedy, okay, what remedy is available? What remedy is available? Okay. Then the second last remedy is what we call bringing election petition. So you petition courts. That's where our workshop lies. Okay, that's where our workshop lies. So first things first, when do we bring this petition in the first place? When do we bring this petition? When? Before we go to who, we are interested in when. When you look at section 60, subsection 3, it says every election petition shall be filed within 30 days after the day on which the result of the election is published by the commission in the Gazette. What does that mean? When you read your facts in the first place and they say on such and such a date, Rashid was gazetted as the duly elected member of parliament of Nakawa East. You underline the word gazette. Once you see that Rashid was gazetted, don't think of any recount. That means recount does not operate. After gazetting, you don't have the right to bring an application for recount. The only remedy you have is of bringing a petition. Okay, bringing a petition, but also it has the limit of time. It has the limit of time. So now, please mark that issue of time. I'm telling you this. Mark that issue of time. Mark that issue of time. Mark that issue of time. Then, what happens when you read, okay? When you read and the intended petitioner is out of the 30 days. The question is, can you make an application for extension of time or not? Or not? Yes? Can you make it? Hey, Council, can we make an application for extension of time? Yes? Members, can we make the application? Or we cannot. So, we can make an application for extension of time, but the question is, under which law? The question is, under which law? When you look at section 60, subsection 1, it says parliamentary election petitions shall be filed in the High Court. So that means the court that has jurisdictions to handle such petitions is the High Court. Which laws do apply to the High Court? We have the Civil Procedure Act and then the rules. When you look at section 96 and 98, they equally refer to that you can make an application for extension of time. But mark this, okay? When you read the case of, it is miscellaneous application number 1 of 2021, arising out of presidential electoral petition number 1 of Robert Chagulanyi Sentamu versus Yoel Kaguta Tahavura Museveni and another. That application they made. But in referring to that, you just speak out the principle. Then you come under section 63, okay? Under section 63, subsection 2, okay? Which say that the High Court shall proceed and hear and determine the matter expeditiously and may pause, suspend any other matter pending before it. When you read that provision, courts do not grant leave within which to file a petition. They don't grant, they base on that provision. Because even court has, the character said that they even pause and suspend all other matters, and for you bringing it out of time. So you read that provision very well, okay? You can also refer to the case of Muhammad, it is Sulaiman Chidandala versus Muhammad Seglin and another. They are very emphatic on such problems with petitions, okay? So what does that mean? That an application for extension of time may not be granted, so don't risk your client's money, but we can eat it, okay? Then another question we have, okay? Who can bring a petition? We've already seen jurisdictions. Who can bring the petition? When you look at section 60, subsection 2, it says the election petition may be filed in court by the following persons. A candidate who loses an election, okay? A candidate who loses, regardless of your which number, we don't care, provided you've lost. Okay, for you to understand that, you refer to the case of this Mwindi man that I've forgotten his name, but he was versing Honorable Joel Senyonyi and another. Okay, they vehemently explained that principle because this Indian was the last runner and he brought a petition against Honorable Joel Senyonyi. So in court emphasizing the right to bring a petition, they vehemently discussed that position. Okay, so refer to the same. Then another person who can bring this, we have a registered voter in the constituency concerned and supported by signatures of not less than 500 voters registered in the constituency. Okay, now when you look at that,
who can bring the petition? Who can bring the
yes,
petition?
we've said one, a candidate who has lost. Then two, a registered voter in the constituency supported by not less than 500 signatures. Okay. For you to also appreciate that, you've seen how Malema Vidizi has been bringing petitions. I don't know whether he was supported, but God knows better. Okay, God knows better. Okay, so but he has the signatures that are required. Okay, now we've seen the court, when and who. Then ask yourself, how do we draft a petition? What are the contents of this petition? You are going to refer to what we call the parliamentary election petition regulations as amended. You go in the different schedules, okay? All the documents you need are there. Please don't draft a petition without referring to the schedule in the rules, please, okay? please, I know you're going to get 30 says, okay? Are we together? Okay. So then, so now, when we council is asking the section for extension of time, we've said extension of time can't be granted. You read section 60, subsection 3 and 4, okay, on trial, okay? So now, after you've presented your petition, we've seen how it is. So what do you prove in the petition, or what are the prayers you include in the petition? So when we are dealing with illegal practices and non-compliance, council asked a certain question that I'm answering now. When you read section 61, it says, so the prayer you make is either that Rashid be declared the validly elected member of parliament, or you say that the said election be set aside and a by-election, you get, so depending on what you want, okay, then it costs. But then when you look at section 61, it says grounds for setting aside election. So they said that the election of a candidate as a member of parliament shall only be set aside on any of the following grounds if proved to the satisfaction of court. If proved to the satisfaction of court. So what does this mean? Once you prove any of these, it is sufficient to set it aside. One, non-compliance with electoral laws. Okay? So once you prove that there was non-compliance, well and good. Then B, okay, that the person other than the one elected won the election. Okay, that the person declared to be a winner did not win. Okay, then C, that there was commission of illegal practices or electoral offenses under the Act, personally or through the agent with consent and approval of the candidate. Okay, then that the candidate was not at the time of his or her election qualified. That means was not validly nominated. Are we together? Okay, so then after that, ask yourself, what is the standard and burden of proof in electoral petitions? Okay. When you look at section 61, subsection 3, it says that the burden of proof is on the basis of balance of probabilities. Okay, so that means election petitions are proved on the balance of probabilities. However, please look at those presidential, petitions. Okay, they have something they refer to always. That question has not been answered. We have what we call the issue of substantiality. The issue of substantiality. What does that mean? That court to make an order of cancellation, that the acts done or the non-compliance must have substantially affected the outcome of the elections. Okay? Read the case of Honorable Joel Senyon. That issue is there because this guy alleged that there was non-compliance and commitment of electoral offenses. But if you look at the number of votes scored by Honorable Joel Senyon, okay, it is a clear indication that regardless of the fact that the actions might have been there, but they never substantially affected the outcome. You've seen the judgments in all the presidential petitions. They look the same. But, so for you to understand the issue of substantiality, you should look at the very case of Honorable Joel Senyon, which is not on your reading list. You look at the case of Dr. Kanokiza Besije versus YMKM7 and another. Sorry, okay? And then you read the presidential petition of Kenya. Very emphatic because that's the only case in East Africa that has proved the issue of substantiality on the presidential grounds. You refer to it, okay? Just to pick out the principles. So now, then we go to what we call principles regarding election petitions. What principles should be put into consideration? Okay, we are basically interested in one. That's what we call service of notice of petition. Please, section 62 is very clear. It says that notice in writing of presentation of a petition accompanied by a copy of a petition shall within 7 days. So that means the notice is supposed to be served within 7 days after filing of the petition. And it should be served by the petitioner on the respondent. Okay? Mark that. So ask yourself, what is the impact of not filing a notice of petition? Okay, what is the impact? You read the case of Fred Nyanzi Sentamo versus Muhammad Nsereko and another. You also read the case of Sulaiman Chidandala versus Honorable Seglinya Muhammad, aka Mr. Update. Okay, you refer to those cases where a court held that non-service of a notice of a petition within the prescribed time and in a manner prescribed is a ground for dismissal of a petition. And that is the very ground upon which those two petitions were dismissed. They were not heard on merit. But because of the negligence and carelessness of the petitioners, they never served the petition, okay, within the prescribed way. But when you are reading the case of Honorable Sulaiman Chidandara versus Honorable Muhammad Segirinya and another, those matters are two. They have an application to use substituted service, okay? Don't read that. Read the real petition when it was, okay, when it was dealt with. You get it, okay? It is very emphatic. Once you don't serve a petition, it is a ground of dismissal, okay? As I've not said that Honorable Nsereko left the country, I have just said that they didn't serve him. Okay, so mark those things, eh? And once time of the 7 days within which to serve, okay, has expired, they don't extend time in electoral petitions. They adhere to the strictness of time. Okay. So are we together? Are we together, comrades?
My internet my Zoom has disappeared.
We've said, okay, that failure to serve a notice as per section 62, it is a ground of dismissal of your petition. So don't risk your client's money. Okay. So ensure that you comply with the same. Okay. So are we together? Okay. Then the last remedy we have is what we call withdrawal from election petitions. Okay. Withdrawal from electoral petitions. Okay. Now, when you look at section 65, okay, okay, are we together? Okay, this is provided for under section 65. Okay, withdrawal of, so the first things first, when you read section 65 subsection 1, it's very clear that an election petition shall not be withdrawn except with leave of court and after such notice has been given as the court may direct. So what does that mean? What does that mean? Okay, once you apply to withdraw, court shall sit and determine your application. Okay, but when you read the rules, the regulations, we have what we call dispute resolution. Okay, so you can also go for dispute resolution and you file what we call no consent to withdraw petition. When you read the case of the recent case, because they have a lot of cases, but the recent case of 2021, okay, it is of that was a consent to withdraw. It was of Honorable Salam Musumba versus Honorable Rebecca Alitwala Kadaga and another. Okay, they just filed a notice. Okay, they filed a consent to withdraw, but they first went for, okay, so you read the rules on alternative dispute resolution. It has ADR, but we have what yes, well, that's where now we are going. So if you don't take that, okay, because have alternative dispute resolution in petitions, if that does not work, you make a formal application to withdraw, and for purposes of that, you will refer to the case of Robert Chagulanyi Sentamu versus YMK Museveni and another. But mark this, in presidential petitions, when you make that application, you are not slapped with costs. But in parliamentary petitions, okay, as per section 65, subsection 4, okay, you have to be slapped with costs. Okay, mark that. Then the very last remedy is what we call abatement of a petition. That is under section 67. Okay, under section 67. So upon death of a petitioner, it automatically abates the petition. Okay, so now briefly, those are the laws we are supposed to analyze. Okay, and then we appreciate the same. Okay, so put that into consideration. But the general issues we have here are basically one, whether that person was validly nominated. Then two, these are the issues you should raise in the workshop, okay? Whether that person was validly nominated. Then three, whether there was commission of any electoral offenses. That's two. Then three, whether there was non-compliance with the electoral laws. Then four, whether there are any areas that require further information. Then five, what remedies are available to the aggrieved candidate in the circumstances. And as per your workshop, the most appropriate remedy is a petition in reason. When you read your facts, the gentleman had already been gazetted. After gazetting, you don't go for recount, you go for petition, okay? But when you are reading at the time of gazetting, look at the period of the 30 days. If this person is out of time, regardless of what, you should think of an interim remedy of an application for extension of time within which to file a petition, okay? Then the last issue is what, no, not the last issue. The second last issue would be what remedies are available in circumstances where the petitioner is no longer interested in the petition. Then you discuss withdrawal, because you have that under task 4. Group 4, you're doing task 7 and 6, yeah? It is inclusive of that. Then the last issue would be, what are the necessary documents? So those are the issues as per your workshop on electoral petitions.
Excuse me, Rashid. Pardon on what you said on issue 4 on the law.
Yes?
Saying on the law that group 4 would use. Pardon on that.
On issue 4?
Yes.
Okay. Issue 4, we've said that what remedies are available in circumstances where this person is no longer interested in the petition. We've said that you look at withdrawal from a petition. You advise him on whether he can go for it or not. We've looked at the section and the cases as well.
Pardon on issue 2 and 3.
We've said issue 1 is whether that candidate who won was validly nominated. Then issue 2, whether there was non-compliance with the electoral laws. Then issue 3, whether there is commission of any illegal practices, stroke electoral offenses. Then issue 4, it depends on the way workshop is structured, whether there are areas that require further information. Okay. Then issue 5, we've said what remedies are available in circumstances where the petitioner is no longer interested in the petition. Okay. Then the last issue is what are the necessary documents in the circumstances. Okay. So time is not on our side, but we should put this into consideration, and inshallah we have to look at workshop 1 still has another part, and that is to say enforcement of human rights and judicial review. I don't know. I'm waiting for your suggestions on how we can handle the same. Either we shall have another session in the evening after your classes. We see if we can stretch even in workshop 2 a little bit, inshallah. So for purposes of time, allow me end this here. But this week is a bit huge, eh? If you've really tested the waters. So let's give it all that we can and we attend. Okay. Whether physical or online, let's all be on. We can make this a success. Okay. And mark this week is basically on workshop on question 2 of the final exam. They always bring that appeal and the judicial review. So we should put that into consideration. Okay. So let me wish you guys the best. Let me let you go for class. My humble apologies. We have started this a little bit late, but next time better, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh. Okay, so